This is tonight's agenda, and as you can see, there is an abundance of information for you to take in this evening, including campaign finances, voters list access, election signs, and campaigning rules. So without further ado, I'll now pass you over to our colleagues at the Ministry of Municipal Affairs and Housing to kick off the presentation.
Okay. Hello, my name is, as Colin mentioned, my name is Bridget Foster, and with me is Colin and Maggie, and we're from the Ministry of Municipal Affairs and Housing. So I'd like to thank the City of Toronto for inviting us and for hosting this candidate session. So these slides that we're going to go through tonight are meant to be a summary of some of the sections of the Municipal Elections Act and should not be relied on for legal or official purposes. I do want to stress that we are not lawyers and that you should always consult the legislation and seek legal advice when necessary. We will not be able to cover every aspect of the municipal elections, but hope that this provides you with a better understanding of the process and legislation and improves your comfort level. Also, just to congratulate you for taking an interest in your community and in local government, whether you're interested in serving on a municipal council or on a school board. So this slide, the highlighted sections are the parts that we will be going through tonight. Those include campaign finances, compliance audit, the voters list, and then just some helpful resources that the ministry provides. Okay, so campaign accounts are only required if a candidate or third-party advertiser raises or spends money. So for campaigns where no funds are raised or spent, there is no need to open a campaign account. Third-party advertisers will generally need to follow the same rules for raising campaign funds and financial reporting as candidates for office. Municipalities must establish rules and procedures regarding the use of municipal or local board resources during the campaign period. This would have been passed by May 1st in the year of the election. This will encourage accountability and transparency, so ensure that you are aware of the municipality's policy in this regard. Also, just to note, the practice of municipalities of providing candidate contact information on their website is not considered a contribution. So contributions from the candidate and their spouse are considered to have come from the same person and count against the self-contribution limit that we will talk about later in the slides. The rules for determining whether corporations are considered to be one contributor are clarified as if one corporation controls the others directly or indirectly, then they are considered to be the same contributor. If the corporations are owned or controlled by the same person or groups of persons, either directly or indirectly, they are also considered to be the same contributor. So candidates and third-party advertisers cannot accept contributions from a federal political party, constituency association, or registered candidate in a federal election, a provincial political party, constituency association, or registered candidate or leadership contestant, federal or provincial government, a municipality, a school board, or a business or group that is not a corporation. So in regards to volunteers, the value of services provided by volunteers is generally not considered to be a contribution. But if a professional, for example, an accountant or lawyer, volunteers to provide services for which they would normally be paid, the market value of the service must be recorded as a contribution by the volunteer and is a campaign expense. So for example, if your accountant friend is typically paid $100 an hour and works 5 hours for you, you would then document $500 as a contribution from them and $500 as an expense. Trade unions and corporations are not eligible to contribute to candidates' campaigns, although they can participate in the election as third-party advertisers or make contributions to third-party advertising campaigns. So campaign contributions are monies, goods, or services given to a candidate for their election campaign. Cash contributions may only be accepted up to $25. Contributions above must be made by check, money order, or a method clearly showing where the funds came from. Regardless of the amount of the contribution, receipts must be issued for every contribution and should contain the name and address of the contributor and the amount and date. Fundraising functions are events or activities held by or on behalf of a candidate for the primary purpose of raising money for the candidate's campaign. The price of admission to a fundraising function is a campaign contribution, and a receipt must be issued for the full amount. So the limit on contributions to any one candidate or registered third-party advertiser is $1,200, with the aggregate limit in a municipality being $5,000. Just to note, if you are running for mayor in the city of Toronto, the limit is $2,500. Since candidates and third-party advertisers are required to inform contributors of these contribution limits, you may want to include their limits on the receipts provided to the contributors. Self-funding limits for municipal council candidates are based on the number of electors voting for the office to a maximum of $25,000 per candidate. This amount includes any contributions of goods such as inventory from a previous campaign. So the formula for calculating the limit is $7,500 plus 20 cents per elector for head of council and $5,000 plus 20 cents per elector for other council offices. The highest self-funding limit that anyone can possibly have is $25,000. So if the formula works out to above the maximum of $25,000, the candidate's self-funding limit would be capped at $25,000 of the $25,000 limit. If the formula works out to less than $25,000, then the candidate would get whatever the formula works out to. So a candidate can open their campaign account with their own funds, but the candidate cannot loan funds to their campaign to kickstart it with the intention of getting it all back. The only way that a candidate can reclaim the startup amount is if there are leftover funds after the campaign period is over and prior to filing the financial statement. At this time, a candidate would have the opportunity to reclaim funds from a surplus. The loan is not considered to be campaign income, and paying it back is not a campaign expense. But if you or your spouse guarantee the loan and the campaign does not repay all of it back, the remaining balance is considered to be a contribution. And in this case, you need to keep in mind the self-funding contribution limit. You cannot accept loans from family members or from any corporate accounts you have access to. The loan must come from a bank or other recognized lending institution in Ontario and must be directed into the campaign account. Also to note, any interest that the campaign pays on loans is considered a campaign expense. So Section 88.19 of the Municipal Elections Act outlines what constitutes an expense. Some examples of expenses are the replacement value of goods, retained by the person, individual, corporation, or trade union from any previous election in the municipality and used in the current election, the value of contributions of goods and services, audit and accounting fees, interest on loans, as outlined under Section 88.17 of the Municipal Elections Act, the cost of holding fundraising functions, the cost of holding parties and making other expressions of appreciation after the close of voting. For a candidate, the expenses related to a recount or proceeding under Section 83 of the Municipal Elections Act, which is controverted elections, expenses related to a compliance audit, expenses that are incurred by a candidate with a disability or a registered third party who is an individual with a disability, and the expenses directly related to the disability and would not have been incurred but for the election to which the expenses relate, and the cost of election campaign advertisements or third-party advertisements, as the case may be. So for greater certainty, the cost of holding fundraising functions does not include costs related to events or activities that are organized for such purposes as promoting public awareness of a candidate and at which the soliciting of contributions is incidental, or any promotional material in which soliciting of contributions is also incidental. So candidates and third-party advertisers should familiarize themselves with the campaign expense provisions and know what constitutes an expense under the spending limits. These can also be found in the candidate's guide. Campaign expenses are costs that are incurred by the candidate or a person under the candidate's direction, such as a campaign manager along with a third-party advertiser in their campaign. The nomination fee is a personal expense and not a campaign expense. Therefore, it is not reported in your financial statement. Goods and services donated to the campaign are also expenses and must be reported. A receipt must be provided for fair market value. So just to note, they are also to be recorded as a contribution. Only nominated persons and or third-party advertisers can incur expenses during their campaign period, or persons acting under the direction during those periods. All expenses must be paid from your campaign account, your campaign bank account, and a receipt must be retained that shows what the expense was for. If you're using a credit card to pay for purchases, you should make sure you keep clear records showing that the expenses on the credit card was reimbursed directly from the campaign account. All expenses must be reported in the relevant financial disclosure form to be filed with the clerk by the candidate or the third-party advertiser. So with respect to campaign inventory, if you ran in the previous election and want to use leftover goods, such as signs or office supplies, you have to determine the current market value of those goods and record them as an expense in the current campaign. Also to note, you must record this as a self-funded contribution on the financial statement. Also, if you end up with leftover inventory at the end of this campaign, it becomes your personal property. But if you want to store them to use in another election, any costs for storage are not considered a campaign expense. Okay, so spending limits are outlined in Ontario Regulation 101.97. The head of council spending limit is $7,500 plus 85 cents per elector. All other offices are $5,000 plus 85 cents per elector. The spending limit after voting day for parties, expressions of appreciation, gifts, etc., is 10% of the spending limit. The clerk's calculation of the spending limit is final. So the clerk will provide two calculations of a candidate's spending limits. The first, the clerk will provide a preliminary estimate at the time of the nomination for a candidate or a registered third-party advertiser. The clerk calculates the spending limit based on the number of electors on the voters list as it existed on September 20th, 2022. The final spending limit is based on the voters list as it exists on September 20th, 2026, and will be provided to the candidates and third-party advertisers on or before September 30th, 2026. Whichever number is higher is the spending limit, and the clerk's calculation is final. Candidates will be required to inform their contributors of the contribution limits. For example, how much a contributor can contribute to an individual candidate's campaign, and the aggregate limit on contributions to any one council or local board election. If a third-party advertiser has registered in more than one municipality, each registration is a separate campaign with its own spending limits. The campaign finance rules are generally the same for third-party advertisers as they are for candidates. For example, they are subject to similar contribution limits and have calculated spending limits as well. This includes financial filing requirements, requests for extensions, and records. Third-party advertisers are also required to ensure contributions and expenses are tracked and accounted for, proper record retention, proper direction is provided to those incurring expenses or accepting contributions on their behalf, and that spending limits are adhered to. Most expenses are subject to the spending limit. Those listed in this slide are not. Expenses related to a fundraising function are exempt from the campaign spending limit, but in order to qualify as a fundraising function, an event must have the raising of money as its primary purpose. Campaign events at which incidental fundraising takes place do not qualify as fundraising functions. So as kind of mentioned before, a brochure promoting awareness of a candidate that contains contact information to make campaign contributions does not qualify as a fundraising function. So for third-party advertisers, there's also two spending limits. One is the general spending limit. The second is a separate limit for expenses related to parties and expressions of appreciation after the close of voting. Ontario Regulation 101.97 provides the formula for calculating third-party spending limits, and those are $5,000 plus 5 cents per elector to a maximum of $25,000. The formula used is based on the number of electors entitled to vote in an election in the municipality. Just to note, the Municipal Elections Act also provides that the spending limit for parties and other expressions of appreciation after voting day is to be set at 10% of the general spending limit. This is consistent with the spending limit that is in place for candidates. So campaign financial rules can be found in the sections noted on the slide from the Municipal Elections Act. This and the next several slides will walk you through the campaign finance rules. As a candidate or third-party advertiser, it is important that you be fully aware of the responsibilities regarding election spending and accepting campaign contributions. You are recommended to familiarize yourself with the sections of the Municipal Elections Act noted on this slide, as well as the financial statements that you will be required to file. This will help guide you in organizing your records and how they have to be reported. You are required under the Municipal Elections Act to keep accurate records and open a campaign bank account if you are spending any money or accepting any contributions. Just to note, a bank account is not required if a candidate or third-party advertiser does not receive nor spend any money. So candidates and third-party advertisers are required to keep complete and accurate financial statements during the course of their campaigns. All contributions and expenses are to be accounted for and disclosed by the candidate on the relevant prescribed financial form. All candidates and third-party advertisers are required to keep all campaign financial records until after the council in the 2030 election has been sworn in and takes office. These rules apply whether you have been elected or not. The clerk must also keep all campaign finance records until after the 2030 council has been sworn in. So this slide kind of outlines some recommendations we have for record keeping. Store receipts in a secure place as they are valuable documents. Receipts must be signed by the candidate or his or her designate. It is good practice to have a receipt that is multi-part form, one for the contributor and one or more for the candidate's records. Receipts should be numbered in order. Open a bank account which provides monthly statements and or canceled checks. Produce duplicate deposit slips for every deposit, listing the names of the contributors and the amounts received from each. Ensure a very good record is kept of all contributions, as sometimes the contributor makes numerous contributions and may exceed the $100 limit, where they will need to be identified within the financial statement in a separate section. So there is that separate section on Form 4 that requires all contributors that contribute over $100 to be listed with their address. It is highly recommended that all candidates make contributors aware that any contributions that exceed $100 will be identified within the financial statement and their address, and this information will be made public. Maintain a petty cash fund to handle minor expenses and obtain invoices to support all payments from the fund. So at any time, the cash on hand plus the total amount of the invoices should equal the original amount of the petty cash fund. The fund can be replenished periodically by a check drawn on the campaign account in an amount equal to the amount of the invoices. Candidates and third-party advertisers may find it useful to look over Form 4, which is for candidates, and Form 8 for the third-party advertisers at the beginning of the campaign to make you aware of an idea of what information will be needed to report on at the end of your campaign. Candidates and third-party advertisers are required to maintain certain campaign records, for example, copy of advertisements for public inspection for a period of 4 years, as outlined in Section 88.3 of the Municipal Elections Act. Okay, it is recommended for candidates to contact the city to inquire about bylaws relating to signs and campaigning. I believe you'll get someone will speak towards that later tonight. Candidates and third-party advertisers cannot cause an election campaign advertisement to appear unless they provide the following information to the broadcaster or publisher in writing: the name of the candidate or registered third-party advertiser, the name, business address, and telephone number of the individual who deals with the broadcaster or publisher under the direction of the candidate or registered third-party advertiser. The third-party advertiser must also include the name of the municipality where the third-party advertiser is registered. No broadcaster or publisher shall cause a campaign or third-party advertisement to appear unless this information has been provided to them. The period for third-party advertisements, as shown on the slide, is the period when the rules for third-party advertisers applies. So in 2026, that was from May 1st until the close of voting on voting day at 8 p.m. on October 26th. Please note that an election sign advertisement purchased by or under the direction of a candidate shall identify the candidate on the sign. The broadcaster or publisher of a third-party advertiser or candidate advertisement shall maintain records containing the following information for a period of 4 years after the date the advertisement has appeared, and shall permit the public to inspect the records during normal business hours. So the records must be the name of the candidate or registered third-party advertiser, the name, business address, and telephone number of the individual who deals with the broadcaster or publisher under the direction of the candidate or the registered third-party advertiser, a copy of the advertisement or the means of reproducing it for inspection, and a statement of the charge made for its appearance. So Section 88.25 of the Municipal Elections Act states all candidates are required to file Form 4 with the clerk regardless of how much or how little they spent or fundraise. The deadline to file your financial statement is Tuesday, March 30th, 2027, before 2 p.m. If you feel you cannot meet that deadline, you must apply to the courts for an extension prior to the March 30th deadline. So again, if you filed a nomination form, you must file a Form 4. This form is required even if you withdrew your nomination or you were acclaimed. If you registered as a third-party advertiser, again, you must complete Form 8. I say this over and over, but it's very important. A candidate may resubmit a financial statement to correct an error up until the filing deadline. The clerk is required to make public a report of which candidates filed financial statements and which did not. So candidates can also file their financial documents at any time after voting day up until the end of the campaign period of December 31st, 2026, despite the March 30th, 2027 deadline. Filing of the financial statement ends the campaign period. This will make it easier for acclamations and campaigns where little or no expense occurred. Third-party advertisers can also close their campaign and file their financial statements after early withdrawal or at any time after voting day and up to December 31st, 2026, keeping in mind the final deadline is March 30th, 2027. Clerks will be required to report whether candidates have met their financial filing obligation and publish a report on the municipal website or in another electronic form. This needs to be completed by April 30th, 2027 in the case of a regular election. The clerk must also, as soon as possible after April 30th, 2027, make a list of all registered third-party advertisers and indicate whether each filed the required financial statement and auditor's report. Clerks can determine the conditions of the electronic filing of financial statements. So the appointment of an auditor by the candidate is mandatory if expenses or contributions exceeded $10,000. The auditor must be licensed under the Public Accounting Act 2004. A recommendation that we have is if you feel that you might meet that $10,000 threshold that would require you to obtain an auditor, please go and seek an auditor early. In the previous election, some people struggled with trying to find an auditor. Just to note that financial statements are public documents. So the nomination fee is only refundable if the financial statement is filed on time. A candidate or third-party advertiser who misses the filing deadline may file within the 30-day grace period, provided a $500 late filing fee is paid to the municipality. The 30-day grace period would end on April 29th, 2027, being 30 days from the financial statement due date, which is March 30th, 2027. Just to note, a candidate who chooses to file within the 30-day grace period will be subject to both a $500 late filing fee as well as the loss of your nomination refund. However, if the candidate is approved for an extension by the courts, the candidate would get their nomination fee back. A candidate or third-party advertiser may resubmit a financial statement to correct an error up until the filing deadline. So when filing a financial statement, a candidate or third-party advertiser with a campaign surplus must pay that surplus, the entire amount, back to the clerk. Prior to paying over any surplus, I think I mentioned this a little bit earlier, a candidate or third-party advertiser is entitled to a refund of any contributions they or their spouse, if an individual, made to the campaign. For example, if a candidate has $1,000 left over and they made a contribution themselves of $500, they would repay themselves back the $500 and the remaining $500 would then be paid over to the municipality. The clerk is required to place surplus monies in trust for use by the candidate if they need it in the event of a compliance audit. The clerk is also required to place surplus monies in trust for use by the third-party advertiser if they need it for compliance audit. If neither the candidate nor third-party advertiser requires the funds for these purposes, it then becomes the property of the municipality or the school board. So now I'm just going to cover some compliance and enforcement rules. So every municipality must establish a compliance audit committee. Members of a compliance audit committee cannot be members of council or the school board, an employee, a candidate in the election, or a registered third-party advertiser. The clerk also reviews contributions and prepares a report for consideration by the compliance audit committee if a contributor appears to have exceeded any of the contribution limits. This process is related to reviewing contributions as reported on the financial statements and is not connected to the compliance audit process. If it is apparent to the clerk that a contributor has exceeded one or more of the contribution limits, the clerk would report this to the committee, which would meet to determine whether to proceed with legal action. The legislation does not specify what details are to be provided to the report to the committee, in the report to the committee. Electors entitled to vote in an election may apply for a compliance audit even if the candidate has not filed a financial statement. The application must be in writing, and it sets out the electors' reasons for why they believe the Municipal Elections Act has been contravened. The application must be submitted to the municipal clerk or the secretary of the school board within 90 days of the filing deadline. The Compliance Audit Committee will consider the application and decide whether to retain an auditor to undertake a compliance audit of the candidate's financial statements. A person who does not want to or who is not able to apply for a compliance audit may decide to commence legal action on their own. A prosecution related to the 2026 election must be commenced on or before November 15th, 2030. If the committee grants the application, it will appoint an auditor to conduct a compliance audit of the candidate's campaign finances, which is why it's very important to keep very, very good records of all your expenses and contributions. The auditor is entitled to have access to all the financial records related to the campaign. The auditor will produce a report which the candidate is entitled to receive. The Compliance Audit Committee will meet to consider the auditor's report. If the report concludes that there is an apparent contravention of the Municipal Elections Act, the committee will decide whether to commence legal action. The Compliance Audit Committee does not have any authority to set penalties. Only the court can decide if a candidate has contravened the act, and if so, which penalties should apply. So there are 3 contraventions of the Municipal Elections Act where penalties apply automatically. They are if you fail to file a financial statement by the end of the 30-day grace period or fail to apply to the court before March 30th, 2027 for an extension by the filing deadline. If your financial statement shows that you exceeded your spending limit, or if you fail to turn over the surplus to the clerk when you file your financial statement. The penalty is you forfeit your office if you won the election, and you become ineligible to run or be appointed to fill a vacancy until after the 2030 election. So if you are convicted of an offense, you may be subject to the following penalties on this slide. They are a fine of up to $25,000, ineligibility to vote or run in the next general election, up to 6 months in prison, and forfeiture of your elected office if the judge finds that you committed the offense knowingly. So I previously indicated that if you were convicted of exceeding the spending limit, you automatically will lose your seat. But in addition, you may also be fined the amount to which you exceeded the limit. So now I'll just go over some rules with the voters list. So Elections Ontario is a nonpartisan office of the Legislative Assembly of Ontario, responsible for administering provincial elections, led by the Chief Electoral Officer. Elections Ontario is governed by the Elections Act and the Election Finances Act. Elections Ontario does not administer local elections, but they do have a role in play in providing up-to-date voter list information to local partners. Since January 1st, 2024, the Chief Electoral Officer has taken over the responsibility of preparing voters lists from MPAC and will manage a permanent register of electors for both the provincial and municipal elections. The voters list for each municipal election will be prepared using data from the Permanent Register of Electors maintained by Elections Ontario. Elections Ontario works with local partners to provide them with the most up-to-date voters list to support their elections. Voters across the province can update their information in the register for local and provincial elections by visiting registertovoteon.ca. There, voters can confirm or add their information to the register. So the voters list becomes a public document on September 1st, 2026. As a candidate, you can request that the municipal clerk provide you with a part of the voters list that relates to the office that you are running for. This request must be made in writing. In order to receive the voters list from the municipal clerk, you must give the clerk a written acknowledgement of the following: that you will only use the list for electoral purposes and not for commercial purposes. You are bound by the restrictions set out in the Municipal Elections Act related to handling of the voters list. You will only share the list with others, such as campaign workers, after obtaining a similar written acknowledgement from them. You are the only person, the candidate, who may share the voters list. If you have given someone a copy, they are not allowed to share it further. You must keep track of who you have shared the voters list with. So if you give someone a physical copy of the list, they must return that copy to you. If you share an electronic copy, they must destroy the copy and provide you with a written acknowledgement that the copy has been destroyed. You cannot keep copies of the voters list after your campaign is ended. On or before the day your campaign ends, you must destroy the copy of the voters list that you received from the clerk, have any printed copies that you shared with other people returned to you, and destroy them. Ensure you have received written acknowledgements from anyone who received an electronic copy of the list that the electronic copy has also been destroyed. So just to note, inputting information from the voters list into any artificial intelligence platform should be avoided, as it may not be consistent with the restrictions on sharing the voters list and only using it for election purposes. Before you share the voters list with someone, you must obtain a written acknowledgement from that person. That written acknowledgement must confirm that they will only use the list for electoral purposes and not for commercial purposes. They will not share or give copies of the list to anyone. If they receive a physical copy of the list, they will return that copy to you. If they receive an electronic copy of the list, they will destroy the copy and give you written confirmation of that electronic copy, that the electronic copy has been destroyed. The written acknowledgement should set out the dates by which people must return physical copies to you or give you the written confirmation that electronic copies have been destroyed. You must keep the records of the written acknowledgements that you have received until November 15th, 2030, when the next council or school board takes office. You must also keep any written confirmations that electronic copies of the list has also been destroyed. So this is just some resources that we have. This list, they're available, and we recommend that you review them to prepare yourself for your campaign. You'll want to be very familiar with the Municipal Elections Act, the Municipal Act, and the Municipal Conflict of Interest Act, as well as we have really great a Canada's guide that we use all the time. So we strongly recommend to review that as well. And that is all we have.
Okay. All right. Thanks, everyone. Well, thanks to the province for that presentation, and thanks everyone for coming today. It's so hot up there. What a nightmare. Holy cow. Okay, so I'm going to talk a little bit about some more specific stuff to the City of Toronto. I'm going to hand it to our friends at MLS to talk about election science. We'll talk about a few more things, and we'll get to Q&A. But I'm going to talk a little bit about the voters list first. So we just heard a bit about it, and I'm going to add to it covering how you get on the voters list. So you might get questions about this when you're canvassing, and then also how you as a candidate get your copy of the voters list. So let's start with getting on the list. So up until August 12th, electors can check, update, add themselves to the voters list using Election Ontario's voter registration application. Around that time, we get sent the preliminary list of electors, and we launch our own My Vote tool on September 1st. So My Vote is a tool. Yes, sorry. That electors can use to check if they're on the voters list, add themselves to the list, update or correct their information. And they can add themselves up to that list through my vote, up to October 11th. And then after that, voters have to wait until voting day to add themselves to the voters list at their assigned voting location. Members of the public can also use that My Vote tool to type in their address to find out what their ward is, who the registered candidates are for their ward, and see their assigned voting place. So getting your copy of the list. Every candidate is entitled to receive the voters list. So as was already covered, candidates have to request that list in writing and acknowledge a number of requirements designed to safeguard the personal information contained on that list. So most of you have already done this written request when you filed your nomination paper at our office, and we ask you to fill out the voters list request form. There's a few of you that we don't have this form from yet. So if you are one of those people, talk to us, come up to us. I think we even have copies of the forms here. We can get you to fill it out now, and we'll just get that off our plate. So as our colleagues explained, the written acknowledgement includes that you will only use the list for campaign purposes and you will destroy your copy after the campaign is complete. And please note, again, uploading the list to any AI tool would contravene the restrictions because once you provide that information through an AI tool, you have lost control and custody of that information. So the voters list is provided digitally. So we provide this voters list digitally to you as the candidates through an application called Candidate Access. Now, we have a lot of applications at the city that you'll have access to. So Candidate Access is just for voters list stuff. It's separate from My Campaign. It's separate from the electronic financial filing system. So what's going to happen is on September 1st, all certified candidates who have submitted that voters list request form are going to receive an email from us that contains your username and temporary password for Candidate Access. Once you log in for the first time, you're going to reset the password to your own, and you're going to agree to an acknowledgement of restrictions that you must adhere to when accessing the list. So the voters list contains names and addresses of each eligible elector that can vote for the office for which you are running. So, for example, if you're running for Councillor of Ward 4, you're going to receive a list that contains the eligible electors in Ward 4. If you're running for Toronto Catholic District School Board trustee in Ward 1, your list will contain the eligible electors that can vote for specifically the Toronto Catholic District School Board in Ward 1. You will also have access to a few other additional lists. So again, the preliminary list, that's the big one that you get on September 1st. The interim list of changes will be available on September 23rd. And then you will have access to a list of electors who voted during the advance vote period after each advance vote date. And a list of electors who voted by mail will be available on October 15th. And again, all of that will be available to download through the Candidate Access portal. So let's talk a little bit about the systems you'll have access to as a candidate. We talked about candidate access. The next is My Campaign. So a lot of you have already actually accessed this already. So My Campaign is a secure portal for candidates, and it allows you to see your spending limits, submit contact information that will go on our public list of candidates, get access to various resources and documents, both broad and specific to your campaign. So this slide contains an overview of what's available through candidates through My Campaign. And My Campaign also links to the electronic financial filing system. Whoa, that totally fell apart. How does that even happen? That I'm going to talk about more right now. I hope I don't need to take any notes. So the electronic financial filing system, which I'm going to call EFFS from now on, is a tool that allows candidates to enter all of their contributions and expenses, produce the financial statement, and if you want to, submit that statement to us electronically. For those of you who are participating in the rebate program, which I'm going to talk about in a minute, it's also what you'll be required to use to generate the official rebate receipt and application form that you have to send to your contributors. So as you enter your contributions and expenses into EFFS, it starts to build out your financial statement. And this is something that you can really decide how you want to approach. It's something you could do weekly during your campaign, monthly, or even after your campaign ends. It's really up to you how you want to utilize that system. Once you've inputted all of your financial data into EFFS, it will do the calculations for you to produce a completed and signed financial statement. And then once you have that, you can either bring that statement into our office and file it in person, or if you don't have a surplus or other money that you owe to the city clerk, which you have to pay to us at the time of filing, so you have to come see us personally, you can submit that statement to us electronically through the system. So for those of you who have run before and used EFFS before, you'll be interested to know that EFFS now has a brand new look and hopefully a bit more of a modern and straightforward interface. Now, it does also have a new method of logging in that involves creating a City of Toronto account, linking it to your kind of My Campaign data, all of that stuff. But we do have steps for walking through that. So the contribution rebate program. The City of Toronto offers a contribution rebate program for candidates running for mayor and councillor, not for trustee, just for mayor and councillor, that allows contributors to your campaign to receive a portion of their contribution back. Participation in the rebate program is optional, but if you choose to participate, there are some extra requirements for both you as a candidate and the contributors to your campaign, which I'm going to go through in a minute. So only monetary contributions totaling higher than $25, which means starting at $25.01, are eligible for a rebate. The rebate amount that a person gets is based on a sliding scale formula related to the total amount that they have contributed. So it's calculated on all contributions that that person has made to all candidates who are participating in the rebate program. For example, if I contributed $500 to 3 different candidates for council who are participating in the rebate program, the formula gets applied to my having made a $1,500 contribution in total. Please make sure your contributors understand this. We see this a lot. A lot of people think that they give $100 to a candidate, they're going to get 75% back on each contribution that they make, which is not necessarily the case. So once you get over $300 in total contributions, the applied formula changes and the return is less than 75%. So maybe they donated $100 to your campaign, and if that's all they did, then they would get 75% of that back as a rebate. But if they're donating a bunch of money to other campaigns, that percentage that they get back could go down. So just be careful when you're communicating that out to your contributors. If you are participating in the rebate program, both you and your contributors have certain obligations. So as a candidate, you're responsible for providing an official contribution rebate receipt and application form for each contribution that you accept. So this form is generated through the electronic financial filing system, or EFFS, that I mentioned earlier, and you must use the system to generate those official forms. When you enter the contribution into EFFS, you have the option to generate a receipt, and doing so generates a PDF of that official receipt and application form, which you can either print out or save and send to your contributors, whether you mail it to them, hand it to them, email it to them, whatever you choose. As for your contributors, they have to apply for the rebate. It is not automatically provided to them. Contributors are basically going to use that official rebate receipt and application form that you give to them and apply for the rebate either by going to our online rebate portal, which will launch in October, or they can do it the old-fashioned way of manually filling out, signing the form, and mailing it to our office at the address on the form. Please note, please, if you're accepting online donations and your payment processor automatically, say, sends out an e-receipt to your contributors and it has a receipt number automatically generated on it, that receipt is not the one they're going to use to claim their rebate. So maybe it has the number 234 on it or something like that. That's not a valid receipt number to claim the rebate. They have to use the receipt number that's on the official contribution rebate receipt and application form that you are going to generate through EFFS and provide to them. Please make sure that your contributors are aware of that, because we get a lot of receipt claims for contributions, receipt numbers that were probably from like a payment processor, and they're not the official form. The deadline for all rebate applications is December 30th, 2027. And please note I'm saying 2027, not 2026. And all eligible contributors will receive a check in the mail in early 2028, which I know seems like a long way away, but it's as soon as we can possibly send them after all the legislative requirements that would affect rebate eligibility and who we can pay rebates to are finally complete. And earlier I alluded to some extra hoops that you as a candidate need to jump through in order to participate in the rebate program. So these are, if you're a candidate participating in it, you have to file an audited financial statement, no matter how much money you raised or spent on your campaign. So our friends at the province mentioned that normally there's a requirement that if you raise or spend more than $10,000 on your campaign, you have to file an audited financial statement. If you're participating in the rebate program, it doesn't matter how much money you raise or spend. Even if you raise $10 and you're participating in the rebate program, for whatever reason, I don't know why you would at that point, but say you are, you have to submit an audited financial statement. You also have to submit copies of all expense invoices and receipts for your campaign to us. And I say copies, please make sure they're copies and not the originals, because we keep them and you need to keep your own records as well. And you have to use the electronic financial filing system to record all of your contributions and expense data, and you have to submit this data to us within 5 days of filing your 5 business days of filing your financial statement. And that's it for me. So I'm going to pass things along to our colleagues in municipal licensing and standards, and they are going to discuss some information about election signs. Thank you.
Good evening, everyone. My name is Ferdy. This is Lucas. We work for the City of Toronto Bylaw Enforcement Unit, representing Municipal Licensing and Standards Division. Pretty much going to tell you guys what is allowed and what is not in regards to your election signs. What we'll be going through with this presentation is the role of the Municipal Licensing and Standards, some general information, what's important, sign placements, both on public and private property, sign storage and disposal, top 10 election sign complaint types, set fines under the Provincial Offences Act, and resources. So the role of municipal licensing standards in the 2026 municipal election is to investigate complaints. Enforcement is reactive and not proactive. We are complaint-based. MLNS does not investigate stolen or damaged election signs. We do sign removal. Election signs found in violation will be removed without notice. And we provide support, answering any questions, concerns via email or by telephone. About the Toronto Municipal Code, Chapter 693, which speaks on the election signs. Election signs are regulated by Articles 2 and 3 of the Toronto Municipal Code, Chapter 693, and stipulates when election signs can be erected or displayed during the election period. Election and campaign office signs can be erected as of October 1st, 2026. Election day is October 26, 2026. All election signs must be removed within 72 hours after voting day or by October 29, 2026. There are no permit or sign retrieval fees. Essentially, what that is no charges to recover a confiscated or illegally placed or unauthorized sign from the City of Toronto. What is an election sign? A sign which has been displayed with the authorization, direction, or involvement of a candidate that advertises or promotes a candidate in a federal, provincial, or municipal election, including a bylaw election and the election of a local board or commission member. Is intended to influence persons to vote for or against any candidate or any question or bylaw submitted to the electors. So this is what's important here. General restrictions: election signs cannot interfere with the safe operation of vehicle traffic. That's essentially any sign that is placed on the city right of way, blocking pedestrian or vehicle traffic. That's not allowed. Another example would be if you put a sign and someone's turning right on an intersection and that person's not able to see oncoming pedestrian or vehicle traffic. Yeah, that sign wouldn't be allowed. Cannot interfere with the safety of pedestrians. So you don't want to put signs out where pedestrians would have to walk off the sidewalk or into a ditch. The city's maintenance operations. So you don't want to put signs around barriers or fences of a construction site. The city's underground utilities. So there's been times where signs were placed with metal rods, and what happened was those metal rods hit a electrical conduit or some sort of a sewage system. So you don't want to do that. The sight lines on roadways. So an example would be placing signs that hang on to a roadway. That's one example. Election signs cannot be illuminated, have flashing lights, emit sounds, or simulate motion. Include use the city logo, crest, seal in a whole or in part. Be larger than 1.2 square meters in area, except election signs on campaign offices. So 1.2 square meters is approximately a meter by a meter. Say like this, like this. Be higher than 2 meters above ground level, except on campaign offices or secured to windows or balconies. So 2 meters, about maybe my height. All right, placement on public property. Election signs cannot be attached to utility poles or boxes, light poles or traffic lights, trees, fences, TTC property or structures without a permit. So none of that stuff, no signs that should be placed on those. Attaching to TTC property, you're gonna require a permit from the TTC. Placement on public property on streets, election signs cannot be displayed within 1.5 meters of the curb, within 0.6 meters of either side of a sidewalk, within 15 meters of an intersection of a collector or arterial road, within 3 meters of an intersection of a local road, on a median or island. That's like the platform that's between two active roadways. Adjacent to a voting place, city park or facility owned or operated by the city, and without the consent of the owner, occupant of the property.
So next we have placement on private property. Election signs may not be placed without the consent of the owner or occupant of the property. Any less than 1 meter from any other election sign on the property without the consent of the owner, within 0.6 meters of the private side of the sidewalk. So here we have a diagram of signs that are not allowed and allowed. So in front of a voting place, it's a no-go, as well as on the public side of the sidewalk in a public park. Any sign that can hinder someone who's driving they're being able to view the street, and within 15 meters of the intersection of a collector or arterial road. Permitted signs on private property with the owner's consent, like the one with the check mark, that is all good. Must meet the campaign office must meet the permanent sign requirements under the Toronto Municipal Code, chapters 694. That would otherwise apply to the sign on the property or unit. Some signs may be grandfathered under a permit issued under the authority of a sign bylaw passed by the city or former area municipality. Candidates for social or for council and trustee may only display election signs in one campaign office, while candidates for mayor may display signs of up to 4 campaign offices. Election signs cannot be larger than 1.2 square meters, as we've covered, and higher than 2 meters above ground, except for the following on campaign offices, on TTC, dedicated advertisement or advertising spaces such as bus shelters, on street installation dedicated to advertising spaces, on third-party advertising spaces like billboards, and when displayed indoors. And these safety precautions are for the people who will be going out and placing the signs. Any individuals who are tasked with placing the candidates' election signs, please take proper safety precautions to ensure your safety and the safety of the public, including all persons working near roadways should wear reflective clothing. Signs should be installed and removed outside of peak travel times and not at night, so you should not be posting them during rush hour. Vehicles should be parked to minimize the impact of other motorists, pedestrians, and cyclists. So if you're posting them near a busy street, finding a parking lot or a side street where you can park and people can enter and exit the vehicle safely would be ideal. Ensure signs are properly placed to avoid being damaged or removed. Please don't place signs where we've told you not to place them, because that means we're going out and we will remove them and we will not be letting you know. They will just be removed. Storage and disposal of election signs. The election signs that have been removed by city officials for being improperly displayed will be stored for up to 72 hours after voting day. Candidates may retrieve their election signs at designated locations after voting day. The designated locations are still being worked out, but you will be notified of those when they do become official. Any sign not retrieved, those will be recycled or disposed of by the city. So this is the time frame of the election and when you can post signs. Your sign period begins on October 1st. You have 25 days. Can post a sign up to 25 days before the election, with the election being October 26th. You can start October 1st. After October 26th, you have 3 days to remove the signs. So on October 29th, any sign will be removed and disposed of by city workers. These are the top 10 the top 10 election sign complaints that we receive. Placed on private property without consent, too close to an intersection, blocking driveway sightlines, being erected for more than 25 days before the voting day, uprooted and damaged signs, not removed within 72 hours after voting day, on or around voting place or advanced polls, on public property, posted on fences, and posted too close to the sidewalks. These are the fines that can be imposed if you, as a candidate, post signs that are unpermitted. Display election signs on sign on public property within 1.5 meters of the curb / pavement edge. Display election sign on public property within 15 meters of an intersection or crosswalk of a major road, or 3 meters of an intersection or crosswalk of a local road. Display election sign, campaign office sign for more than 25 days prior to voting. Display election sign on public property adjacent to a voting place / city park, city facility on the advanced voting days or voting day itself. Fail to remove election sign, outside of election sign 72 hours after voting. A fine can be issued for each individual sign to a candidate. Most bylaws that come with set fines. They're all $500, and with service fees and everything go up to $615. This is a link for road classification system with all the numbers that we, or the distances that we have being different for local, collectors, and arterial roads. This link will tell you what roads are what and where the distances are that make them within the bylaw.
All right, folks, that's pretty much all for us. If you have any further questions, this is the contact information. There's an email address there, electionsigns@toronto.ca. Telephone number is 416-392-3082. They're open Monday to Friday, 8 a.m. to 4 p.m. I believe this slide will be shared with, or is on the website. So please contact them if you have any further questions. Thank you.
All right, we're almost done, I promise. I'm the last speaker, so then we'll get to your questions. So what I am going to start off with is let's talk a little bit about ballots, specifically when will you all get your sample ballot? So beginning in early October, the date will be communicated to you. Each candidate will be able to access a copy of the sample ballot through My Campaign. So basically how your name and where your name will appear on the ballot on election day. Each candidate for an office is listed in alphabetical order by last name and will have an assigned number. You can use this information on your campaign material. So if you want to be like, I will be number 3 on the ballot, vote number 3, feel free to do that. Okay, I'm going to move on to all candidate debates because this is something we often get questions about. All candidate debates and meetings are organized independently of the City of Toronto. So we here at Toronto Elections, we are not responsible for holding all candidate debates. In fact, we often do not know about them if they are organized. The Municipal Elections Act does not mention them or require them to be held, and as I said, we often are not made aware of them. Typically, they are organized by community groups such as BIAs, the media, other organizations, things like that. And these groups do not inform us and are not required to inform us of when and where they are happening, and if they indeed will hold all candidate debates. They don't tell us who they are inviting. We don't have a say in who they are inviting to these debates. Now, the only thing that I will say, the only exception, is that if an all candidate debate is being held on City of Toronto property, this is allowed only if all candidates for that office are invited. So that's the only scenario where all candidate debates can be held on city property. Now, one thing I'm going to note about all candidate debates relates to accessibility. So the Municipal Elections Act does not stipulate anything about accessibility and whether all candidate debates have to be accessible, so we don't get a say in it. But you as candidates can play a role to ensure that all candidate debates are accessible for the people that want to attend them. If you're invited to an all-candidate debate, you might want to consider inquiring about the accessibility of the venue or the facility that it's being held at to ensure that any elector or candidate that requires extra accessibility needs is able to participate fully in these debates. Okay, now I'm going to talk a little bit about canvassing. I'm sure many of you have already started this. Candidates are able to begin raising and spending money on their campaign, meaning they're also allowed to begin canvassing as soon as they file their nomination paperwork. As a candidate, you have the right to access apartments and condos between the hours of 9 a.m. and 9 p.m. for the purposes of canvassing. Now, both through My Campaign and on our website, you can download a letter to landlords, which is on city letterhead and basically outlines the legislative right you all have to access these premises between the hours of 9 and 9. Now, despite providing this letter to many property managers, some of them still might not want to allow you access to the building. And in those cases, what we suggest, you can get them to give us a call at Toronto Elections. We can explain the legislation to them, try and get you access to the building. But at the end of the day, what we often advise is that there are many, many, many hundreds of buildings in the city of Toronto. In some cases, it's better just to cut your losses, move on to the next building. It's often a better use of your time. Another thing that I'll say is, like, again, you have the right to enter these facilities. However, it's often a good idea just to give the property manager a call in advance, just to give them a heads up that you want to be entering their building. And oftentimes that kind of smooths the process of getting you access to the building. Now I want to give you a few rules to be aware of. So with very few exceptions, you are not allowed to canvass or campaign on city-owned property. Now, the exceptions that I will say is that you are allowed to canvass and campaign in public parks and on 4 different city-managed public squares. These are Nathan Phillips Square here at City Hall, Mel Lastman Square outside North York Civic Center, Albert Campbell Square outside the Scarborough Civic Center, and David Pico Square outside Metro Hall. Now I'm going to move on to canvassing on voting days. So you are allowed to campaign and canvass on election day. However, candidates cannot canvass anywhere on the property where voting is being held. This includes parking lots, playgrounds, fields, etc. You are not allowed to canvass there. Now, the one exception to this is that if a voting place is located in an apartment or condo that is being used as a voting location, you are not allowed to canvass in common areas. However, you are allowed to canvass on residential floors as long as there's no voting place located on that residential floor. Okay, I'm going to spend a little bit of time on scrutineers, because again, this is something that we get a lot of questions about and can result in some issues. So scrutineers play a very important role at the voting place, but generally speaking, their role is as an observer and not as an active participant. They cannot communicate with electors and they cannot interfere with the voting process. Now, a few things scrutineers can do. They can enter the voting location 15 minutes before it opens to the public. They can observe the voting process and object to any elector they feel is not qualified to vote. For this, they must speak to election officials. They cannot speak to the elector or interfere with their voting. At the end of the voting day, they can place their seal on the ballot box, and on election night, they can view and sign the results tape. Candidates are allowed 1 scrutineer per ballot issuer and 1 scrutineer at the vote tabulator. And again, in early October, we'll provide you a list of how many scrutineers are allowed in each of the voting places. You'll get that through My Campaign. As a candidate, you are responsible for making sure your scrutineers understand and follow the rules. Candidates must complete a scrutineer appointment notice for each of their scrutineers. Scrutineers must identify themselves and sign in when entering a voting place and show the form to voting place staff. The scrutineer must also keep this form with them at all times when they're in the voting place. Candidates and scrutineers cannot wear anything that identifies or promotes themselves in the voting place. Candidates and scrutineers can and will be removed if they are disrupting the voting place or process. Now, the role of a scrutineer is to observe that voting is taking place in accordance with legislation and election policies. Questions or concerns about that legislation or about those specific policies should not be directed to voting place staff, but rather you can direct it to us at 416-395-0025 or candidateinfo@toronto.ca. Finally, I'll note that candidates can also act as their own scrutineer. They are required to follow these exact same rules, with the exception that they do not need to fill out a scrutineer appointment form. Instead, they must just identify themselves as a candidate to voting place staff, sign in, and provide identification. Okay, so we're getting to the stuff that we're all working towards, advanced vote and election day. So you can see here on the slide above me, these are the dates you should be aware of. Now note, during advanced vote, voting takes place from 10 a.m. to 7 p.m. And then election day voting takes place between 10 a.m. and 8 p.m. Okay, moving on, election night results. The results for advanced vote and mail-in voting will be generated at our 89 North Line office at 8 p.m. And candidates and/or your scrutineers are welcome to come to 89 North Line to observe this process. The results tape will be posted in the same fashion as they're done in each voting location. Unofficial election results will be posted on the Toronto Elections website beginning at around 9 p.m. And the official results will be posted on the websites a few days after Election Day, and this includes the poll-by-poll results. All right, last slide. So, anytime you have a question, we have an abundance of resources here, all providing contact information. So feel free to use any of the contact information on this slide here. If you want to contact us directly at Toronto Elections, you'll be speaking to either myself, Christopher, or one of our election assistants. The phone number is 416-395-0025, or the candidate info email address. We also have contact information for election sign inquiries. Note, any complaints about election signs shouldn't be emailed to electionsigns@toronto.ca or the phone number provided. They should go directly to 311. And this is so MLS can properly track and send out bylaw officers if there has been a violation. And finally, here is the contact information for our friends at the province as well. Now, something we said at our last info session that I want to make very clear is we here, us staff, we do not provide interpretation of legislation or campaign advice. So if you're asking us a very specific hypothetical question that kind of falls in the gray area, we're not going to give you a yes or no answer. We're often going to say, please seek your own